Hello, everybody. This is Adam Brown, A Brown ESQ, and today we are doing the appellate review of emancipation. And I'll sprinkle in a little what children's preferences mean to the court as well. So, in this case that's come down, again, unpublished, not a precedent, can't rely on it in court. We talk about these cases because they're interesting cases to me. I like their thought exercises, and I think they help my practice, at least in family law. Now here we go. This case came down and was decided January 8th. That's yesterday. They have the people's names in it. I'm not going to say their names. I want to say their address. Their initials are L.P.B versus B.D.B. Essex County case. Great lawyers, great law firms. Certain lawyers, when you see them, you tip your hat. They know what they're doing. Excellent cases. Essex County in general, excellent judges in general. So this is pretty much as good as it's going to get with legal argument. It's 15 pages, but it's very informative, especially if you're kind of trying to get an idea of what the laws in this area of emancipation. But again, you can't rely on this opinion. But anyway, listen. So in general, this situation involved two people who have a child. The child reached the age of majority, 18 years old, and the child was going through some things. Mental things that involve them going to a psychologist, and them having a really tough time, opposition defiance disorder, different disorders that they were diagnosed with that really, went to, their ability to really function in society. And so, what's the test? The test is once someone turns 18 years old, there is a presumption that that person is of the majority. But in the state of New Jersey, this was amended, and this case talks about that in 2016. If you are between 18 and 23 and you attend like school full time, then you still can have child support paid. You're still dependent. You still can have that. Obviously, in New Jersey, at least, when there's emancipation, there's no more child support. So, in this case, the person's child's 18, and is going through a lot mentally. This law applies to people who are disabled, mentally disabled, whichever. And one parent said, "Look, the child's 18. This is no more child support. We're done." But this child is having, or this 18-year-old person is having episodes, and is going through things, and these lawyers are really good because they got expert reports to talk about how the child can't manage their own affairs. She can't maintain employment. And so what do you do in those situations? Well, you can petition the court to continue financial maintenance. And that's exactly what the party in this case wanted to do. And that party came armed with expert psychological reports saying this child can't work and can't maintain employment. And the judge shut the argument down. The judge ruled at the trial level, expert or no expert, this is the presumption, it's over. No more child support. They appealed the decision, and this happens quite often. Sometimes in situations where you go to court, a lot of people think the judge can just easily make a decision. That's not the case, especially if you're unrepresented. A lot of people who are unrepresented go to court and say, the judge just called the whole case a custody case. And really, if I'm sitting in my chair going, no, 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 and the other person in the other chair is going, yes, 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 and I've got some evidence and they've got some evidence, it's going to take a trial to really get to the bottom of who's right and who's wrong, especially when you're talking about a child and their best interest. So that's what the law says here. You know, the law says if there's a disputed fact, and in this case there was an expert report, which was really strategic and smart, because once you have that expert report, that is what they're arguing is the presumption. Yeah, child's 18, that's one presumption, so the burden shifts to the other parent. Well, here's an expert report, it can't work. Burden shift back to you. It's time for trial, and that's what the appellate division did here. Something you should note real quick is the rule is if the child, to see if the child's emancipated, is if they're beyond the scope of influence, meaning like, are they running their own show and just living in your house? Maybe they're working full time, whatever the case is. It's if they're beyond the scope of influence, if they can pretty much operate independently, to see if they're emancipated. A lot of people kind of also ask me these questions when children are kind of getting close to that age. You know, this child's close, can they just choose where they want to live? The answer is no. That still falls into the factors there has to be a best interest analysis. That's one of many factors. It could weigh heavily, it could weigh lightly, their opinion could be influenced unduly. At the end of the day, the children, we know what's best, they don't. And you know, you have to build the case around what is best in their best interest. Not what you want, not what they want, their best interest. And that's what the judge does. There you go.